Hello and welcome to The View from Mayer Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It's presented by Nicholas Robertson, the head of Mayer Brown's London employment team. This podcast is available via iTunes, YouTube and the Twitter feed Nicholas Robertson, Twitter handle @NicholasRobert11. It is also now available on Spotify, Google Play and Yahoo. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions.
Hello and welcome. This is Mayer Brown Employment Law podcast number 187. And it's a special episode. I'm delighted to be joined by Nicolas Simon, who's a partner at Van Olmen and Wynand. He specialises in employment law. The firm itself, it's an independent law firm specialising in employment, corporate law and litigation. It's been around nearly 30 years now, and it's a very well-established player in the Brussels legal market. We've done a lot of work with the employment team over the years, and it's really out of one of those projects that we came up with the idea of doing this podcast. Nicolas joined Van Olmen 2007. He's been a partner since 2018. He's fluent in Dutch, French and English, so I'm eternally grateful to him for doing this podcast in English. He himself has extensive experience in individual employment law as well as collective labour law, including collective actions and strikes, social security transfer undertakings. He's got a particular specialism on privacy issues related to new technology, as well as discrimination and harassment issues. I understand that he can claim to be the man who made the Belgian trains run on time after winning restraining orders during strikes during 2017. And his approach has now been confirmed by Belgium's Constitutional Court, which is quite a feather in his cap. So, Nicolas, we're delighted to have you here.
Thank you, Nick.
And I also think we should have a policy in future that all podcasts need to be staffed exclusively with people called Nicolas or Nicholas. I think that's very appropriate. So the idea that we were discussing was to highlight things which, in your experience, are a surprise to employers who are outside Belgium and who are encountering Belgian employment law for the first time. So what I'm going to do is I'm going to hand over to you. And I think the first thing on your list, because I've seen the 5 things, the first thing on your list, you said you're going to be talking about dark periods, which I have to say sounds very 2020. So please put my mind at ease. What dark periods are we talking about in the context of Belgian employment law?
Yes, so every 4 years we have a social election in Belgium. And regarding the social election, if you take the election day, which would be X, we have a so-called dark period where you don't know if your employees are on the list to be employees representatives. So if you take the election day, so X is the election day, 35 days before, there is a posting of the fact that there will be a social election, and then the employee, the candidates, are protected against dismissal, and this goes until 35 days after the announcing of the election date, because it's the date when you have the list of the candidates. So it means that there is a period or 70 days where you are not aware of the fact of an employee is a candidate or not to the social election. It means that you cannot dismiss him, or even that you have to be careful with all the employees of your company, because unless they are at CIO level or just under, they are possibly candidates. It means that there is a kind of freezing period before the social election where you cannot dismiss the employees. For the current period, it started in August, and until the 16th or 19th of November, you cannot dismiss an employee without the risk that he will be candidate. And the fines are very high because employees representatives are highly protected in Belgium, and it can go up to 8 years remuneration as protection indemnity. There is calculation about 2 parts of the indemnity. The first part is about the seniority of the employee. So we look less than 10 years seniority, between 10 and less than 20 or more than 20, and it's up to 2 to 4 years indemnity. And then on top, you have to pay the remuneration until the next social election. It means 4 years. So the risk is about 8 years remuneration. So you have to be very careful about that.
Goodness me. So in short, your elections all take place at the same time under Belgian law for companies, and employers can be guilty of and fined even if they did not know that someone was a candidate for a post, and therefore in practice it's a freezing on dismissals because the risk of dismissing staff goes up very significantly in this period. Is that right?
That's right. It's a huge risk because the employee could ask for reintegration, but there is a risk he will just claim the indemnity. So there is a period, yeah.
Gosh, wow. So that's certainly something that's extremely important for employers who would be considering redundancy exercises, that there is a period of, I think you said it was 35 days before and 35 days after. There's a 70-day freezing period when the risk profile for redundancies is much higher. And so employers need to have presumably finished the redundancy before or started it afterwards to stay clear of the freezing period.
That's right.
Wow, yeah, that's certainly very, very different to the UK, where I think it would be very unlikely that an employer would be penalised if they could say they honestly did not know that someone was a candidate for election. It would be different if they knew, but if they didn't know, that would almost certainly be a complete defence to any claim for victimisation or something like that. Very different. Well, that's certainly a dark period. So. Good stuff. Okay, so let's move on to the second topic. And now this one I do know a little bit about because I've had employers express incredulity to me that this is the case. But 13th month and double holiday pay. So just how does that work and what is the impact that has?
So you have to be careful in the employment contract to not foresee an all-in clause about the remuneration, because it's from public order in Belgian law to have an end-of-year premium, so a so-called 13 month, so it's equal to 1 month. And then also a double holiday pay. It's a little less than 1 month. It's 92% of a month, but it's on top of the remuneration. It means if you mention a remuneration in the employment contract saying it's all in with the double holiday pay, with the end of year premium, it's not valid because Supreme Court case law say you have to mention it apart. And if you have an all-in clause, it will be calculated on top. So it's important when you draft your contract to be careful with that.
I can see that I bet you've had employers be caught out horribly with that they realise that their wage bill is going to be rather higher than they had judged beforehand.
That's right, and most of the time employers say, "Well, why it's not possible to have an all-in clause?" And we say, "No, Supreme Court case law is really clear about that. It's not possible."
Yes, we have a similar concept with holiday pay, where you're not supposed to pay holiday pay rolled up with certain salary. But the court has said if in practice you can prove that there is a holiday pay element in there, for sure, you might get away with it. It's a little unclear. But we have no concept of a 13th month or anything like that. So it's that's a really important point, I think.
Another important point is also if you pay a variable remuneration, I mean bonus or things like that, you have also to calculate single and double holiday pay on it. It means that you have 15.67% on top to pay on that. So it's important to be careful when you foresee an amount to an employee to look at the holiday pay and the end of year premium because it can increase your cost.
Certainly. Understood. Okay, thank you. That again is a big point. So we've been talking about, we've talked about indemnities and damages for dismissal and so on. Looking at the landscape in Belgium for terminations, one of the things I've noticed is that notice periods can be longer than in some other countries and so on. What in general is the sort of position on Belgian law on things like garden leave, notice periods, and so on? What's the position?
I would say notice periods are longer in Belgium. There was a reform at the beginning of 2014. So before, I would say there are exceptions, but before 2014, you have to count 1 month notice period for 1 year seniority. Now it's a little lower. It's 1 week for the first 3 months, and then there is an increase until 5 years to 15 weeks, and then for each year 3 weeks on top. But the notice period are very long, and the question that we often have is, well, if I have a poor performer, what can I do? But the notice period are the same. If you are a poor performer, that doesn't change anything. The only thing is dismissal for cause, but it's theft. It's very limited. But for the rest, poor performer is just the same notice period as for another person. What is different and interesting is normally, unless for employees representative, you don't need a green light to fire someone, and there is no right to reintegration. So you can dismiss the employee. You have to be careful about the reasons for dismissal, because after 6 months of seniority, you have to mention the reasons of the dismissal. So it must not be an abusive dismissal. But for the rest, it's you can always dismiss someone. Also, a question we often have is garden leave. Is garden leave possible under Belgian law? But it's not possible, because during the notice period, you have to give work to the employee. And if you say stay at home is considered as a constructive dismissal, and the immediate consequence is that you have to pay indemnity in lieu of notice immediately. So most of the time we say, well, if the employee does not agree, you have to dismiss him with immediate effect and the indemnity, or just let him go to work and work during the notice period.
Goodness. Okay. So one question I had: you mentioned notice periods. Are notice periods laid down by law? There's a lengthy notice period that is compulsory by law. That's the way it works.
Yes, indeed. So based on your seniority, there is a notice period. So stipulated by law, so you have no discussion about that. What you could have as discussion, if you pay an indemnity in lieu of notice, you will have a discussion about the remuneration. It means the monthly salary, but also the benefits in kind, the advantage of the car, of the different insurances and things like that.
One thing we haven't talked about, but I just wanted to ask off the top of my head, is I've also come across, I think, restrictive covenants under Belgian employment law can be quite restricted, and that it's very difficult. You know, we can have covenants that could prevent people from competing or soliciting clients for a year or 18 months. I think it is more restricted under Belgian law, isn't it? That's, again, something that is quite restrictive.
Yes, indeed. Regarding restrictive covenants, we have two kinds of restrictive covenants. I would say that the regular one is only for Belgium, so no broader than the country. It's very strict, and then you have to pay an indemnity corresponding to the half of the forbidding period. So it means if you have 1 year non-compete after the end of the employment contract, you have to pay 6 months remuneration for that. And it's something you do not have to forget if you dismiss someone in certain conditions, because you have 2 weeks after the end of the employment contract to renounce to the non-compete. If you don't do that, you have to pay the 6 months.
You're liable. Yes.
And then the other one, it's more the international non-compete. It means that if you are a company with seats of activities in several countries, you can foresee a non-compete clause for different countries, but not too much. And you have to be also precise, because you cannot say Europe. You have to list the countries. You cannot say the whole world. So you have to be careful not to be excessive. And then it's possible to foresee some derogation and also a longer period. But in any case, you have to pay an indemnity corresponding to the half of the non-compete period.
Interesting. It's fascinating, because under English law, we take completely the opposite approach. A clause is either valid or invalid. And if it's invalid, you don't make it valid by paying for it. You can't buy a valid clause. It's conceptually, totally different. I think it's fascinating that the two laws go totally different, and the idea is they're both protecting the employee, and we are saying employers shouldn't be able to buy a covenant that restricts an employee if it's unreasonable, and your law says it's only reasonable if you're paying the employee half the salary for the period.
That's right, and it goes further. If the clause is not valid, the employee can claim it to receive the indemnity, but you cannot enforce it because your clause is not valid.
Wow. Now that sounds like a real defeat if you have to come back to a client and say, well, I've got some bad news and some bad news. Gosh, goodness me. Okay. Fine. The languages. A number of European countries have quite strict restrictions on the language that documents have to be in, termination notices being in a particular language, etc. What's the Belgian position on that?
Yes, in Belgium it's quite complicated about the languages. I think the first important thing is English is not an official language in Belgium. It means that everything that's in English is not valid. The employee can claim it, but it's null and void for the employer. It means that for the company you have to be careful with your policies, with all the documents about bonuses, variable remunerations and things like that, because if you mention targets, the employee could say, well, it's in English, so it's not... you cannot claim it against me. Then, on top of that, we are a small country, but with a lot of languages. So it means, if you look at the Flemish part of the country, so more in the north, it's Dutch, that is the official language. Then, if you look to the south, to Wallonia, it's French, but with an exception for the eastern cantons, it's a German-speaking area, so it's German who's applicable. And then in Brussels, it's a bilingual region, so it means that you have to look at the mother tongue of the employee, so French or Dutch, and you have to draft the document in the correct language. And also, if you have, for instance, an employee who's only speaking English, most of the time you will choose in Brussels one language, Dutch or French, but because it's the official one. But what you have to do is to stick to the same language. You cannot change of the language because the document will not be valid.
Goodness me, does that mean employees are obliged to tell you what their mother tongue is?
Yes.
Goodness.
In Brussels.
What? That's remarkable. Yes. No wonder everyone, you can speak so many languages, because presumably it's just part of working life. You have to be able to speak a certain number of these to, practice in Belgium. But that's a real trap for unwary employers who haven't taken proper advice before setting up arrangements. If the employer can enforce the contract against them or clauses against them, but not be bound by the corresponding provisions in the same document if it's in the wrong language, that must cause massive problems, or potentially massive problems for employers.
Yes, and you have also to be careful, for instance, if you have to prepare a dismissal letter, you have to look at the language of the contract, but also of the social documents, and be careful that it's always in the right language. For instance, you have a company seat in the north of the country who's moving to the south of the country, then you have to be careful because the language have changed, but maybe not the contract. Also, for specific work condition, you have to be careful with that.
Yes, I can see that. Goodness me. Well, that's certainly, again, that's an incredibly valuable point, because there's nothing like that in English law whatsoever, for English employment law. And I know I've had clients, and I don't know whether it was Belgium, whether it was another European country, because it's not unique to Belgium, this you have to be precise about the language that you use. I think France might have a similar provision. And clients furious because the person who was taking advantage of the point, the employee, spoke brilliant English, but because the termination letter or whatever had been delivered in English, he was saying, I did not understand it, it's not in French, it's not valid. And trying to explain to them, it doesn't matter. He had a right to have the document in a particular language. It's an artificial barrier to to an English employer or a US employer. But it's extremely important to know that. Okay, final one. I wanted to ask, the UK, like Belgium, has been particularly hit by coronavirus. I think it is changing the way we work. And one of the big debates that's going on in the UK at the moment is, what's the future of work going to be like? Are we going to work from home dressed in a T-shirt, as I am, or are we going to work in the office dressed in a suit, as you are? And teleworking and remote working and flexible working accelerated through the existence of the pandemic. What's Belgian approach to teleworking or flexible working, and has it been affected in any sense, or is it being given impetus by the existence of the virus?
So if you look back, there was teleworking, but on structural basis. It means some days of the week. Then regarding the work-life balance with the family life and then work life, teleworking was also possible on occasional basis. But now with the COVID-19, it has become compulsory for a certain period during the lockdown. And then more and more there were discussion about what about the teleworking, what about the reimbursement of cost. And for instance, in Belgium, it's interesting because you have a lot of taxes or social security contribution to pay, but there is a specific indemnity for teleworking, about 130 euros a month, and it's not considered as remuneration, so no social security contribution, no tax. Even if you are working only 1 day a week at home, you can receive the whole indemnity. Then on top, if you are using your own computer, you have an indemnity for 20 euros. Most of the time it's the computer from the company. But what is also interesting is that you can receive the indemnity of 20 euros per month for the using of your private internet connection. Because most of the time it's paid by the employer. And then also for teleworking, there is a possibility to pay 10% of the remuneration as indemnity. It's accepted by the social security authorities, so no social security contribution. But for the tax purpose, then you have to have an agreement with the tax authorities. And the last thing with teleworking, where employers are most of the time happy, is that you cannot have overtime during teleworking. So you can have certain periods when you have to be available, but there is no overpay for overtime.
Oh, interesting. Again, can I ask you, and we haven't talked about this before, so I'm going to ask you a question that I haven't given you any warning about. But one of the things that we're seeing in the UK is a big debate, or the beginnings of a big debate, about the employer's ability to monitor employees who are working from home and what systems they can use to check what work the employee is doing. And I think this is a big issue in the United States. And I've seen a number of very good articles in the UK on the subject. Are you seeing, and of course in Europe, in the UK and Europe, we have the benefit of the GDPR and data protection rules, which gives some protection. Are you seeing this as a topic for discussion amongst Belgian employment laws or Belgian employers about the extent to which they can measure what employees are doing when they are working at home, most of the time, or indeed all of the time? Or has that not been a subject where there's any concern that employers are going to try and do remote monitoring?
Well, indeed, the monitoring is a good question, because if you look at the regulation about teleworking in Belgium, at the beginning it was linked to home working. Home working is working at home, but for instance in textile industry or things like that, so not necessarily with IT. And so you have no control on the employee. Then you have more and more ICT in the last 30 years and then 20 years ago. So you have the possibility to monitor the employee. And we make the difference between teleworking and home working, because teleworking, you have a kind of possibility of control. But in fact, and it's also the reason for overtime, monitoring the employee on distance is not that easy. You can see when the employee is logged in and so far, but you will more measure the work that's done, that the will control on time, during the working time.
Fascinating, because I think there's a real fear so the articles I've been reviewing, I think there are some quite sophisticated surveillance routines that employers have access to. And the question is whether employees are aware of what necessarily is being measured and monitored. So it'd be fascinating to see whether that's something that's a concern that becomes shared more widely, or whether, people writing about it are unnecessarily fearful. And I think it's a bigger issue in the US, where you don't have some of the data protection that we have in Europe. So fascinating. We'll have to have a look at that. Okay. Well, look, that was interesting. And I think, if I may say so, you chose 5 really interesting points. So I think any employers will be really interested to learn about them. I wanted to finish, and I always like to ask my guests a question, and it's usually about a favourite book or film, or piece of music, and why. So I think you've chosen a piece of music. So what is it, and why have you chosen it?
So my piece of music that I've chosen is Asibonanga from Johnny Clegg and the group Savuka. So it was dedicated in South Africa to Nelson Mandela, and I like it because I think diversity is very important. And if you look at the group at that time with white and black persons, and also the message for Nelson Mandela, it was I think very important worldwide, and also it's really a good message. And it means also you can have if you have a diverse team, you can achieve great things, and you have different point of views. And if you look at the actuality, I think diversity is more and more important for the people themselves, but also for companies, because you can have a better view, better ideas, and also different point of views.
Couldn't agree more. It's a fantastic choice. A friend of mine saw them play at the end of the 1980s, maybe early 1990s, and said it was one of the best concerts she'd ever been to. But it was also at a time when they were, I think, viewed with hostility by the South African regime. So it was pre-Nelson Mandela getting out. And she said there was an element of danger about the whole concert as well. This was in London. But she said it was one of the most fantastic things she'd been to, and I am so jealous that I never got to see them play live. I think my personal favourite is Scatterlings of Africa, but we can continue that debate offline after the podcast. So, Nicola, thank you so much indeed. That has been genuinely fascinating, and thank you for making the time. And that's been really informative, and I'm sure people are going to find that really, really interesting. So thank you very much indeed, and thank you too for your musical choice.
Thank you.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions, or want to know how to claim continuing education credits, please email Nick at nrobertson@mayorbrown.com. Thank you for listening to the podcast.